Johnson County criminal defense attorney. What happens after you're released? Do you think your charge will just go away? It's not going to happen in Johnson County. So you got charged, you're in Johnson County. What are you going to expect now? You're going to see things on myCase, you're going to CCS, you're going to see charging documents, you're going to see initial hearing documents. Maybe there's bond conditions, maybe there's a no contact order. All of these things are going to be things that are filed and things that you're made aware of if charges are filed against you. If you were taken to jail, generally speaking, depending on what it is, if it's a misdemeanor or a lower level felony, what's going to happen is you're going to sit in jail for a little bit. You're eventually going to get a bond, or you could just be released, what we call OR, released on your recognizance. But you're going to get some kind of a bond, could be a cash bond, maybe a bail, something like that. You're going to get out, you're going to be given an initial hearing. Now, sometimes you will still be in jail for that initial hearing. It happens all the time. It really just depends on what the charges are. At that initial hearing, if you have hired an attorney, if you've hired us, we're going to be there at your initial hearing. If you haven't hired anyone, at the initial hearing, what's going to happen is the court's going to tell you, here's what you've been charged with. Here's what the probable cause affidavit says. They're going to tell you if there's any no contact order. If you haven't posted a bond or you haven't been given one, a court's going to set one at that time. And again, that could be $200, $500, $1,000, $10,000. Could be a surety bond, could be a cash bond. There's a lot of different kinds. So what's next? Well, at this initial hearing, you're going to be given some dates. If an attorney represents you, if we represent you, the court's pretty much going to give those dates to us, but they apply to you. You're going to hear what's called an omnibus date. In the court, generally, most judges are going to tell you when you're standing there. The omnibus date, you don't really need to worry about. It's something your attorney needs to worry about because it's a deadline for filing charges or amending charges. The court's also going to give you a pretrial conference date. That's going to be your next hearing date. The court might also set a bail review hearing. Let's say the court set bail at $5,000. It might set a bail review hearing. The court might also set a trial date at that time. Some judges do, some judges don't. So you're going to get some dates on some different times that you need to be back in court. And then, aside from those initial documents that got filed, what's going to happen is as you progress, that's when the evidence is going to start to be presented. If I'm your attorney, what the prosecutor is going to do is they're going to send me a link, and it's going to have the discovery that they have initially. So this is their initial discovery. And again, that's the charging information. That's the probable cause affidavit. A lot of times, Johnson County is very quick about body cam. So they might send me the body cam initially. Maybe there's a breath ticket. If they did a breath ticket and they already have results. Maybe they already have the results of a blood draw if this is an OVWI, for example. Maybe there was security cameras or security footage of the place you were at, and maybe they were able to get that. They're going to send whatever they have initially to me. Now, that's not always going to be all of it, right? Oftentimes, labs haven't come back. Oftentimes, they haven't been able to get all the video footage yet. Oftentimes, there might be some other evidence, maybe witness statements, things like that they haven't provided yet. They're going to provide those in what's called supplemental discovery. They have an obligation to do that. But initially, they're going to provide us with initial discovery. So depending on what your case is, will depend on kind of the way our discussion leads. If the case is, it's an OVWI and you come and you talk to me and you're like, look, yeah, I had been drinking that night. I probably was intoxicated. Okay, then the steps we're going to take, I'm going to tell you, look, maybe there's a way to beat this. Maybe there's a way to beat this at trial. There can be. That's going to be something that I'm going to need to review. I'm going to need to look at the body cam. I'm going to need to look at that OVWI affidavit. What did the officer do? What didn't the officer do? But we might also have a conversation of, okay, let's assume that they can make their case. Let's assume that they would find you guilty. How do we put you in the best position to get the minimum jail time or the minimum home detention time or the minimum probation time? How do we put you in the best spot? So we're going to talk about mitigation. What can you do now? And that can be, well, if this is an OVWI, then I'm going to tell you, go get an evaluation done. Or if this is a drug case, go get an evaluation done. See what that eval says. If that eval tells you to do treatment, go ahead and start the treatment. If this is your first OVWI, I'm going to tell you, hey, go do what we call the AAID. It's an alcohol destructive decision panel. It's going to be required if you take a plea. Go ahead and get it done. Do some of these things beforehand. Additionally, what we might do is, if this is driving related, we might talk to you about SDP. If this is drug related, same with alcohol, we might talk to you about a treatment. So depending on what the case is, we might talk about things that we can do to make you look better and to give me a stronger argument when I'm talking to a prosecutor to say, hey, look, this guy's not the guy you need to go hard on, right? He's not the guy that you want to put in jail for 2 years. So let's give him probation. So what are some common mistakes? What are some common things that can happen? Well, the biggest one is missing court. Never miss your court date. It is so important. And that is something that at our office, we send follow-ups. We're going to send you follow-up messages, and we're, 5 days before court, we're going to send you a reminder. Hey, you have court. Anytime we know of a change, we're going to let you know of a change, because if you miss court, that is the quickest way to get picked up on a warrant. And sometimes sometimes you're not going to be getting out of jail until your case is resolved. Don't post about your case. Depending on what your case is, if you start posting about your case, a prosecutor could use that. And maybe what you're saying you don't think is going to hurt you. Maybe you think it'll help you. But anything that needs to be said about your case, let your attorney say. Because if you start posting about your case, if you start posting about, oh, the alleged victim's lying, or oh, this or that, it could end up really hurting. Third one, and honestly, probably the most common, is violating a no contact order. If there is a no contact order, do not violate that. And I understand sometimes it's really hard. Sometimes this is a domestic situation and a husband is alleged to have hit his wife, or a wife is alleged to have hit her husband. And so there's a no contact order. And that means that the defendant, they can't go home because the other person is living at the house. And they're like, where am I supposed to live? Where am I supposed to stay? I understand that's a tough question, but you cannot have contact, right? You can't text, you can't call, you can't reach out, you can't go to that place. Because if you do, Johnson County, like many others, they're going to file that IOP, an invasion of privacy, immediately upon finding out. And so you violate the no contact order 2-3 times. Not only are you going to go back to jail, but now what you looking at a 2-year sentence all on probation is now all of a sudden a 4-year sentence where you spend a year and a half in jail. So don't do it. So what can we do to help? Well, the first thing we could do is when you hire us, we're going to tell you what we can do initially. So if you call us and you say, hey, look, I think charges have been filed when there's a warrant out. I haven't been arrested. Okay, maybe we can get that warrant recalled. If you call us from jail and you say, hey, look, I've been arrested. I'd like to hire you guys. I'm in jail right now. They gave me a bail, but I can't afford bail. It's $10,000. Okay, we can immediately file for a bail review and we can try to get that bail much lower to a number that you can actually afford. So kind of what can we do in those initial steps? There are times that we can look at the case and we can immediately see some issues with it. Or there are times I can look at a case and I can say, hey, look, based on this, I could probably get you out of jail and have this case resolved very quickly if you're willing to do some things. So that initial period can be really important. So what we're going to do if you hire us, we're going to immediately get to work. We're going to see what we can do initially. And then we're going to make sure that we're setting you up in the best position. If you go to trial, great. Hopefully we can beat that case at trial. But if you don't go to trial, and statistically, most cases will not go to trial, what can we do to put you in the best position to where if you plead open in front of a judge, or if you take a plea that has an open sentence, or if we're negotiating with a prosecutor, what can we do to minimize the sentence that you get? So if you've been arrested in Johnson County, or if you've been charged with anything in Johnson County and you need an attorney that knows how the Johnson County court system works, give us a call at the Marc Lopez Law Firm. The number is 317-632-3642. And remember, always plead the fifth.